Just got off of Court TV talking about a case out of Oregon where victims' family members stood up in court at a sentencing hearing objecting to the plea agreement by the prosecutors. And this brings up two very important aspects of our criminal justice system that we, as a team of former prosecutors at the Bianchi Law Group, see regularly. Regular questions from new prospective clients and new clients about plea bargaining and authority. First is that the prosecutor is the sole responsible party for determining what the appropriate plea offers are from the government. And a lot of states, including New Jersey, have made changes to their laws and their state constitution about victims' rights and how victims need to be treated, victims' families be part of the process with prosecutors. And we get a lot of questions on this, but the victims' rights given by the Constitution does not give victims' families the authority and discretion to dictate what an appropriate plea agreement is. It's the prosecutors. The prosecutors need to evaluate the strengths and weaknesses of their case. They need to take into consideration about aggravating and mitigating factors. And most cases do not go to trial. So most cases do result in plea bargains, and the plea bargaining authority comes from the prosecutor's office. They can consult with the victims and victims' families, but just because victims' families do not agree with the plea bargain being offered, that does not give them veto power. And this was seen in the case that we watched today on Court TV in Oregon, where family members got up and just told the judge that they were not happy with the 18-year sentence on a manslaughter case that the prosecutor extended and the defense took. There was no trial. There was a sentencing proceeding that was televised by Court TV, and you could see that the family was not happy whatsoever, which leads me to the second thing that we learned from today in the criminal justice system, and that is the judge can go lower than the plea as negotiated and accepted by the defendant. As we saw here, the prosecutor was asking for 18 years on a first-degree manslaughter plea bargain, and the judge went lower. Yeah, the judge went down to 10 in custody and the rest on probation. And we frequently talk about this on our huddles with our team of former prosecutors about the sentencing authority from the court. Once there is a plea bargain, once that plea agreement has been signed, then there's what's called an investigation report, a PSI, pre-sentence investigation report. It's done by probation on the court side and given to the court at the time of sentence. At the time of sentence, the court has that plea agreement, which essentially caps the time that the court can give, so long as it's legal, it's binding, and oftentimes, like Jersey, if the judge goes higher in the state system, then the defendant can take back their plea. And anything that they've said during the plea colloquy will not be used against them. But similarly, the judge can go lower and the prosecutor can't appeal that, so long as the term, that is the sentence, is legal. So two things about today's Court TV that we talk about regularly with all our prospective clients and our clients about: one, the sentencing authority of the court. They can go lower than the plea agreement, and the plea agreement's authority with prosecutors. They're the ones that control the pleas. And while victims and victims' families have been given a lot of rights under the state constitutions and laws, they do not have veto power. They don't dictate. It's the prosecutors that have the authority to extend plea agreements. Wondering what you guys think about that. If you have any comments or questions, drop them in the comments below. Take care.